Hello everyone, welcome to Legal Darshan. This is the final last video in the AoR series we were doing. Now this is a bonus drop as a last video for the AoR exam series. So the main target was to cover 86 cases which were listed in the list of AoR leading cases. All of the cases have successfully been covered, and today in this video we are going to have a quick thematic review of all the judgments. Okay, because when we were doing the judgments we were doing them number wise, 1, 2, 3 and all, but today we are going to look at the thematic interpretation, a thematic review of the judgment, because throughout so far we have discussed that the judgments did have some kind of interconnections. So we are going to make the themes according to the subject, and then we are going to discuss each of the judgment in just 1 or 2 lines so that you have a quick review of them. For of course, for the detailed discussion on them, separate videos are already on the channel. For almost all the cases we have uploaded it, right? So I hope your preparation is going really well. I hope you are all set for sitting in the exam on 16th, and of course in the AoR leading case exam on 21st, right? Now, for a quick information, the Supreme Court of India has uploaded this notice on the website just yesterday, informing about the sitting plan. So you may go to the AoR website and you can check your roll numbers, the venue for your exam, so that you have the knowledge of it earlier and you do not waste time finding it later on, right? Now this is the sitting plan, and I will come back to our judgments. Okay, now this is the list of leading cases. We are going to discuss the 86 leading cases by understanding the themes. So we will start with the first theme. The first theme is the theme of basic structure doctrine. So, whenever we start studying constitution, we start with the first case, which is the His Holiness Keshwanand Bharati versus State of Kerala. So in this case, we all know that basic structure doctrine was propounded, preamble was taken in as a part of constitution, defeating what was said in Ray Bari's case. And based on Keshwanand Bharati, since 1973, the Keshwanand Bharati has been decided. It has become an undefeated precedent to determine rights of the people. So, for example, separation of powers, we have fundamental rights, interplay between fundamental rights and DPSP, we have judicial review, we have separation of powers, we have division of powers, federalism. All of it is being transpired from the basic structure doctrine that was propounded in His Holiness Keswanan Bharati versus State of Kerala, a landmark case being decided by 13 judges bench. Then, following Keswanan Bharati, we do Minerva Mills case, which reaffirms the basic structure doctrine and reaffirms that judicial review. Okay, in basic structure doctrine, in this case, we will primarily focus on judicial review. Okay, so now Minerva Mills is talking of judicial review when it says that the Article 13, the power under Article 13, that if there is any law in derogation of fundamental rights, it will also extend the judicial review to the amendment as well, and it therefore invalidated Article 368 clause 4 and clause 5, which took amendments out of the purview of the judicial review. So Minerva Mills is one case which upholds again that basic structure doctrine includes judicial review, and judicial review cannot be segregated from that. Moving on, when we are discussing judicial review, we cannot forget case number 23. Okay, so our case number 23 is IR Kolo versus State of Tamil Nadu. Now, this also says that in the 9th schedule, which is titled as land reform. So 9th schedule, we know that it was put beyond the scrutiny of judicial review. But in IR Kolo, the court is holding that all the entries, all the subjects that was put in 9th schedule after Keshwanand Bharati's judgment shall be subject to judicial review as well. Okay, so 23 IR Kolo's case also does have a direct nexus with the application of Keshwanand Bharati's judgment, as we are discussing herein and as we have discussed in the case earlier as well. Now we come back to the first case. The next theme we are going to discuss is interpreting Article 21. So when we talk of interpreting Article 21, now the next theme that we go on to is interpretation of Article 21. Okay, now when we start interpreting Article 21, we travel back from A.K. Gopalan to Maneka Gandhi to now K.S. Puttaswamy as well. Okay, but A.K. Gopalan found its dissolution as soon as Maneka Gandhi came. Now Maneka Gandhi, the court is judicially reading into Article 21 the due process. Okay, the court is reading due process and principles of natural justice in Maneka Gandhi's case and holding that procedure established by law means due process of law, and a person cannot be neglected his chance of availing principles of natural justice. That is, the procedure established by law needs to be due process. It should be fair, transparent, as well as bona fide procedure. Okay, justice and good conscience should be the principle to follow herein, right? Minerva Mills is also giving us the golden triangle, 14, 19, 21, saying that the three articles are not independent of each other, but rather they are interconnected. Okay. Now, when we study interpretation of Article 21, Minerva Mills becomes one landmark case. But after Minerva, we do have some cases in the list which are directly interpreting our Article 21. So one such case is the case number 48, 43 and 48. Okay, 43 and 48. Now, 43 and 48 are both touching on right to privacy. Right to privacy being a fundamental right under Article 21. And Justice K.S. Puttaswamy is building on previous notions of privacy that were built in the case of Navtej, Nalsa versus Union of India, etc. So right of privacy comes out as one interpretation of Article 21 from the case of Justice Puttaswamy and Justice Puttaswamy versus Union of India 1, as well as 2, in which Aadhaar Act's validity was being examined and right to privacy was upheld, right? As an intrinsic element of Article 21. Following the list, we have case number 44 as well, which is Common Cause versus Union of India. And it is talking of right to life under Article 21 includes right to die. So this is a direct interpretation. Right to die. This is also a direct interpretation of Article 21 that we are discussing under the theme of Article 21. So Common Cause versus Union of India, following the case of Aruna Schonberg versus Union of India and taking lead on previous cases like P. Rathinam and Gyan Kaur, it held that right to die is an intrinsic element under right to life, but not in the case of active euthanasia, but rather passive euthanasia, and laid down guidelines when advanced medical directives, advanced medical wills can be signed, can be executed, and when relatives may also sign advanced medical directives for their aggrieved relative in the cases of passive euthanasia, right? A detailed discussion has been done. You may visit the videos and learn more about the cases, okay? Now coming on to our next theme. Okay, so we have discussed the basic structure doctrine. We have discussed right to life, Article 21 interpretation. So it's not that other cases are not touching on Article 21, but rather the theme is made such like that Article 21 is directly being interpreted by these cases. Okay, now we come to the affirmative action. The next theme of the discussion is affirmative action. Okay, so now in our affirmative action, when we look at the cases of affirmative action, if you are watching this video today, and if you have watched the previous video I have uploaded on affirmative action, it was a set of 4 videos altogether, right? So one is the case of Indira Sahni versus Union of India. Another is Jarnail Singh. Then next is State of Punjab versus Devinder Singh. And fourth one is our EWS case, which goes by the title Janhit Abhiyan versus Union of India. Now, these cases are based on the affirmative action on the reservation policies. But apart from that, we in this segment, along with affirmative action, we are also going to touch upon the judgments which are based on minority rights. So far, this particular theme of affirmative action, reservation, and minority rights, minority reservation, we are going to discuss so far 8 cases altogether. Okay, So now we start with the case number 7, which is Indra Sane versus Union of India. Now in Indra Sane versus Union of India, what happened? Now, in Indra Sane versus Union of India, we know that there was an upper ceiling of 50% for reservation allowed, and it basically let down the quota of 27% for OBC non-creamy layer, as well as it said that there shall be no promotion in reservation, leading to which the parliament brings the amendment. Okay, parliaments bring the amendment and allowed reservation in promotion as well. Okay, now when we come to Jarnail Singh case. Next case in the list is Jarnail Singh case. Jarnail Singh is numbered at 49 in the list. And Jarnail Singh is basically known as reservation and promotion case. Okay. Now this case is overruling, partially overruling Nagaraj judgment. And Supreme Court says that in this case, there were 3 conditions that were let down in Nagaraj case, and Supreme Court in Jarnail Singh is saying that in this case there is no constitutional mandate on the state to collect quantifiable data to determine inadequacy of representation of SCs, STs in the service, and it is also holding that you do not get to determine if the class is backward or class is not backward, because they have been given the benefit of being backward itself. Backwardness is the element of the caste, and that is why the rule has been made there. So reservation and promotion was upheld, and it was said that M. Nagaraj was partially overruled, saying that there is no need of inquiring into backwardness of the candidate at that particular time. Okay, because in Indra Sahane, it was also held that caste can be a sole criteria of determining reservation, of determining affirmative action as well. Now, moving on to classification only, we have the case of State of Punjab versus Devinder Singh at number 83. It is basically talking of SC/ST sub-classification, and the judgment is given by 7 judges bench. The judges bench by 6:1 majority, holding that SC/ST sub-classification is useful. It can be done because it will decrease the schism between the advanced or economically advanced marginalized communities, economically advanced SC/ST communities, and economically disadvantaged SC/ST communities as well. And even in this judgment, Justice Gawai is basically advocating for SC/ST NCL, like the layering and non-creamy layer and creamy layer quotas that is given to OBC. Similar classification is being suggested by Justice B.R. Gawai also. Overall, State of Punjab versus Devinder Singh is holding out that they are also relying on Indra Sahni and saying that yes, there can be in a same level of caste. The caste is not always homogeneous. There can be some castes in SC who are more backward and some which are advanced. And even this distinction has been given in the case of Indra Sane, saying that there can be more backward and less backward classes as well. And the idea of affirmative action is to benefit the most disadvantaged. That is what the State of Punjab versus Devinder Singh is holding out. Then next is the case of Janhit Abhiyan. Now, Janhit comes as the challenge to 103rd Amendment Act. That Janhit comes out as a challenge to 103rd Amendment Act, which provides 10% of the reservation for 10% of the reservation for economically weaker sections in unreserved communities. Okay. Now, when we look at Janhit is being decided by 3:2 majority, upholding the EWS judgment because the upholding the EWS amendment because EWS was brought in on the challenge. The case was brought in on the challenge that it basically disqualifies all other communities, the reserved communities, and therefore the challenge is the amendment is violative of Article 14 because it violates the principle of equality and therefore violates the basic structure doctrine. However, by 3:2 majority, EWS judgment was upheld, and it was said that economic deprivation is one kind of discrimination that needs to be observed, and therefore the benefits, the affirmative actions needs to be advanced to economically weaker section of people as well. Now moving on reservation only, we come to the minority rights. Okay, so we start by first looking at, because this is a thematic study, we are not actually sticking to the number of judgments. We will first look at AMU versus Naresh Agarwal 84th judgment. So your AMU judgment is basically saying which institutes are minority institutes. How do you determine the minority status of an institute? So AMU versus Naresh Agarwal is saying that if the benefit is extended for the minority communities, if the purpose is to benefit minority communities, and the ideation of making such institute is the brainchild of members of minority community, then that will be a minority institution, irrespective of the fact that it is being administered sometimes also by non-minority members as well. Okay, so here in the two-fold test that the court is propounding is that who is being advantaged and who is the parent of that institution, whose brainchild is that institution. So if both of them, if benefit and if brainchild, both of them are being done and done by and done for the minority person, then in that case that university, that institute is going to be a minority institute. Okay, however, in this case, it was not determined whether AMU is a minority institution or not. But however, Aziz Basha 1967 judgment was overruled by five, which was given by 5 judges bench, and this is a 7-judge bench decision. Okay, now let's come to another cases which are relating to are minority status only, minority education only. So TMA Pai and PA Inamdar both are the judgments that are talking of state interference in minority education institute. In TMA Pai, there was a division of aided and unaided institutions. So in aided minority, we are talking of minority institutions only. So in aided minority institutions, the court held that state have involvement because they are aided. So autonomy is not at its peak in aided institutions, but whereas in unaided institutions, state does not have a right to interfere with respect to, any kind of policies. And in unaided institution, the state will only interfere for when there is maladministration or when then these institutes are charging capacitation fees. Okay, and then comes another case, which is Pramati Education and Cultural Trust versus Union of India. Now Pramati is basically drawing a balance between Article 15 Clause 5 and 21A. Article 15 Clause 5 came ahead and it came ahead of TMA Pai and PA Inamdar, was challenged in Ashok Kumar Thakur. However, it was upheld. But 15.5 says that state may provide reservation, state may provide reservation criteria, state may reserve seats and provide reservation criteria in the institutes apart from minority unaided institutes. Apart from minority institutions, state may provide reservation quota. Now the court in this case is saying that Article 15 Clause 5 and Article 21A are to be construed harmoniously, and both of them promotes the purpose of education, which is also forwarded by the Right to Education Act. Okay, so you can go back and you can have a look at all the judgments that have been discussed in detail on the Legal Darshan channel. For any information, anything you want to know more, any subject you want me to take up further, because this is the last video in our AoR series, I will be glad to take that up. You may also write any suggestions, any doubts you have to me at my email ID also. I'm writing it here. The ID is legaldarshan@gmail.com. The ID you can find in the Dropbox description box below as well. Okay. Now moving on to another theme. Now we come to the theme of judiciary. Okay, so judiciary has itself decided many cases. Okay, many cases judiciary has decided to keep the spirit of independence of judiciary going on. So one such case starts when we start this journey. It is pertinent that we start with the most landmark judgment, which is the case of Skaura versus Union of India, which is Supreme Court Advocate on Record Association versus Union of India. The exam you are going to appear in tomorrow, day after tomorrow, and this Supreme Court Advocate on Record Association versus Union of India is 2015 case, and it is also known as the four judges case. So it is also known as the four judges case. And in this case, the NJAC, National Judicial Appointment Commission, as brought in by the 99th Amendment Act, was struck down, right? Because separation of powers needs to be upheld. And therefore, to maintain judicial independence, we need a strengthened judiciary, strengthened collegium system to determine who will be taking on the role of judges. Because NJAC had a lot of flaws, and most specific is the executive interference in it. Supreme Court Advocates on Record Association judgment struck it down. Moving on to another case, we have next case number 56. This is related to the Supreme Court registry, in which Subhash Chandra Agarwal, who is an RTI activist, he files an RTI seeking the assets, seeking the salary, seeking the assets of the Supreme Court judges. It was first denied by the CPIO of Supreme Court. CPIO is Central Public Information Officer. But later on, when this case goes before the Supreme Court says that there is a division, there is a, division between what is the personal protected information that can be exempted in RTI Act, and there is an information which is important to be known for, securing the faith in an institution. So in this case, asset declaration was held to be done, and the case also challenged the decision of collegium. The court herein ordered that the request for looking into collegium decision can be looked into by the CPIO, but asset declaration was one thing that the court commanded in this case. Okay, so we just know that most recently in 2025 only, a lot of judges have declared their assets. In the Supreme Court, there was a full page reading in leading newspapers that many of the judges have declared their assets, right? Now, next we come to the case of Kavita Kamboj. Okay. But before Kavita Kamboj, we will just look at Dheeraj Mode, because it is on our way only. Now in Dheeraj Mode, the High Court versus Honorable High Court of Delhi, the Supreme Court is basically focusing on Article 233. The challenge pertained in this case was that some judicial officers applied to the direct post, holding that they earlier had 7 years of litigation experience, and then they held the post of judicial officers, CJM, JMFC, etc. And then they are now applying for session judge under Article 233 vacancies, right? So court herein is saying that once you have assumed the office of a public servant who is in the capacity of serving either union government or state government, you are a judge, you have to come through the internal promotion within service channel, and the direct entry is only available to the practicing advocate. So the court herein is clarifying that we have kept the incoming judges for session judge, for district judge, from both the sides, that is from the bench as well as from the bar, so that judicial wisdom can be enhanced. Therefore, case number 62 is holding out that for direct entry, judicial services, people involved in judicial services already, they are not eligible even if they have 7 years of prior litigation experience before joining the judicial services. They can come through the internal promotion channel, but not from the direct vacancies. Okay. Now, next is the case of Kavita Kamboj versus High Court of Punjab and Haryana. In Kavita Kamboj, High Court is making some guidelines with respect to the percentage, cutoff percentage, 50% in viva voce, as well as in written test. And the unsuccessful petitioners are challenging that. Okay, so the court herein is holding that it was fully in the domain, in the light of Article 235 of the Constitution of India, that High Court can make rules regarding that. So Article 233, 234, and 235 is an interpretation in this case. And this was what was held in the case of Kavita Kamboj versus High Court of Punjab. Moving on. to the case of Tej Prakash Pathak versus High Court of Rajasthan. Now, in this case, what is happening? That the Rajasthan High Court changes the passing percentage criteria, makes it 75%, but after exam. Okay, so now this particular mandamus was issued in favor of High Court of Rajasthan, holding that the court cannot do so. Okay, and because you cannot make some cutoff, bring some cutoff post exam, it has to be notified earlier, because that is what doctrine of legitimate expectation warrants. Okay, so 86 is also discussed here. Now these 5 cases were the cases on the judiciary. Okay, how judiciary takes into account the cases that comes before it against itself. These, and now when we are discussing judiciary, how can we forget the tribunals? Okay, so now for tribunals, we have to start with the case on, yes, L. Chandra Kumar versus Union of India. L. Chandra Kumar versus Union of India overruled SP Sampath Kumar's case and held that tribunals are not the substitute to High Court, but rather they are subordinate to High Court. The judicial review power of 226 of the High Courts and Article 32, they are the basic structure doctrine that the judgment reaffirmed judicial review and held that tribunals' judgment are also subject to judicial review of the High Courts. And by virtue of Article 227, High Court exercise subordination on all the courts that are based in the territory of the state, and therefore High Courts are not, tribunals are not substitute, but rather subordinate to the High Courts. Okay, moving on to another case. Another case is the case of Roger Matthew versus South Indian Bank. I'll just come to the judgment. Yeah, Roger Matthew versus South Indian Bank Limited, and we will read together Madras Bar Association, because both of them are challenging legislative overreach that was given in Section 84 of the Finance Act 2017, holding that executive may appoint tribunal chairperson and members of the tribunal. Now, both of the cases challenges the guidelines, the rules, regulations that were issued in exercise of Section 84 of the Finance Act. And in both the cases, these regulations were struck down because they were violative of the basic structure doctrine. They were violative of the separation of powers and independence of judiciary as well. Now, in Madras Bar Association, the court makes a recommendation that a National Commission for Tribunal appointment should be made, so that the appointments can be checked, and the chairperson shall be the Chief Justice of India or the judge nominated on his behalf to monitor the appointments happening in these tribunals. Okay. Now, whether this act was a finance act or not, in Roger Matthew, the court wants to refer this decision to a larger bench, not agreeing with the Justice Puthuswamy's case, because in Roger Matthew, court is saying that we do not find it very perceivable that Aadhaar Act was a finance act as well, and we cannot say whether Finance Act, the present Finance Act 2017, is a finance act as well, is a finance bill, money bill is passed by virtue of a money bill as well. So whether these two will, these two are valid acts passed as money bill has to be looked into by a larger bench, and therefore a larger bench reference was made in the case of Roger Matthew, and therefore also brought in light its pertinent challenge on case Puthuswamy judgment, which held that Aadhaar Act was a valid act being passed as a money bill, right? So this was a conflict that happened, and now a larger bench reference has been made. Now, moving on, because we have done so far Skaura, CPIO, and Kavita Kamboj, Tej Prakash, Dheeraj More, also L. Chandra, Madras Bar, Roger Matthew. All of them are available in detailed version. You may go back and have a look at the full-fledged videos uploaded. Now, let's come to the state. Okay, the next topic we are going to do, the next theme we are going to do is the theme of the state. Okay, what is state? under Article 12. Okay, so the landmark case, the case that we are following till date, is the case of Pradeep Kumar Biswas, and we are traveling from way back from Ajay Hasia to PK Biswas and also to BCCI, where it was held that what qualifies as a state. So we look into the parameters. What is the function the entity is discharging? What is the control of the government that is being exercised? How are the finances being made? What is the shareholding of the government? And whether financial assistance, what is the extent of financial aid that is being given by the state to the industry, that helps in determining whether the entity is a state or not, right? Now, when we look at the state, one question comes. Okay, so because we are discussing state, we discuss PK Biswas, we can't discuss it without one question, whether judiciary is a state under Article 12 or not. Okay, so now this is being answered. Whether judiciary is a state under Article 12 or not, this is being answered in AR Antule's case, where the challenge pertained to a judgment given by judiciary itself. Okay, so in AR Antule versus RS Nayak that we have discussed in the leading cases, the challenge was that the judgment given earlier by the Supreme Court is per incuriam and needs to be rectified. Certiorari was filed basically. So can the court issue certiorari against itself? Can court, itself be a state so as to validate application of Article 32 or 226 against it? The court is saying that we need to divide the duty of courts in two parts. One is administrative and one is judicial. So when it is discharging judicial duty, it is not state, but when it is discharging administrative function, it is state. Okay, so you can question administrative actions of the judiciary by way of Article 32 as well, by way of writ jurisdiction as well, but not the judicial function when it is discharging. So judiciary, when it is discharging administrative functions, it is state and not otherwise. Okay. Now, the third case that comes is Kaushal Kishore in the series of state. Why state? Because in this case, some prominent political leaders, ministers, they made statements about a rape victim, and there's the father of the rape victim. He claimed vicarious liability of the state. The court denied vicarious liability of the state, but however, insisted on the horizontal application of fundamental rights as well. So this case comes in scrutiny under Article 12 as well, because Article 12 only says that fundamental rights are applicable against state, which are, entities covered in Article 12. But with Kaushal Kishore, the court is saying that especially Article 19 and Article 21, they should also be enforced against private entities as well. Therefore, enforcing not just a vertical, but also an horizontal application beyond state of the fundamental rights as well. Okay. Now moving on. We have done state, we have done judiciary, we have done tribunals. Moving on to anti-defection laws. Okay, so in anti-defection, we have three judgments at hand. One is Kihoto Holohan. I'll just come to it. So one is Kihoto Holohan versus Zachilu. I recommend, it is highly requested, highly recommended that, once you are across this video, please make sure that you have this list open with you and you have some paper pen with you. It's better if you have printout so that you can take 1 minute notes of all the judgments to make the interconnection later on. Okay. Now, when we come to anti-defection, Kihoto Holohan versus Zachilu is basically saying that speaker's action, whatever speaker is deciding on anti-defection, that is subject to judicial review. Okay, because 10 schedule para 7 said that judicial review cannot be done on what speaker says. The para is struck down in the judgment. Speaker's decision on anti-defection, it is protected, it is challengeable under judicial review. That is what Kihoto Holohan is saying. But however, Kihoto Holohan is also enforcing that none other than speaker has the power to inquire into anti-defection as well. Okay. But however, what happened in Kisham Meghachandra, which is numbered at 59. Okay, Kisham Meghachandra is supplementing basically, what is happening in Kihoto. Now in Kisham Meghachandra, the speaker does not take an action on anti-defection petition that is filed before him for a prolonged period. And therefore, the petition lies in the Supreme Court, and Supreme Court propounds and explores on the doctrine of quia timid and says that we are not interfering with the speaker. But one speaker fails to do his constitutional duty within a stipulated time frame, within a reasonable time frame, we are going to invoke our jurisdiction and we are going to direct the speaker to take up the proceedings. We are not interfering with the merits of the proceeding, but rather we are just directing him. And this is not violative of Quixote Holahan, because Quixote Holahan says that judiciary cannot intervene in the merits. We are not intervening in the merits, rather we are just saying that speaker should initiate into looking into the case, looking into the queries. Another case is Subhash Desai, that is numbered at 60, pardon me, that is numbered at, I'll just see, 74 in the list of AoR leading cases. Okay. So now Subhash Desai is basically the Maharashtra Legislative Assembly case where Uddhav Thackeray gave resignation, the speaker initiated floor test, and so on. Now, a larger reference was made larger bench reference was made in Supreme Court with respect to Nebam Rebia judgment in Subhash Desai, because in Nebam Rebia it was held that a speaker who is undergoing removal proceedings himself, he can also initiate removal proceedings in the case of failing floor test or anti-defection as well. Now this question is gone before a larger bench and the court is not examining it because Nebam Rebia is being questioned in this case as well. But however, the court in this case is saying that floor test cannot be initiated by the governor. Floor test cannot be initiated by the governor only on the basis of the intra-party tussle, the political party tussle. Okay, there needs to be constitutional breakdown of constitutional machinery so as to initiate the floor test. But however, the court is not restoring Uddhav Thackeray's faction of Shiv Sena because Uddhav Thackeray resigned himself. So a resignation is voluntary and court is therefore not restoring the government in Subhash Desai's judgment. Okay. Now, this is on anti-defection, and from anti-defection, we move to, I'll just give me a minute. There are a lot of judgments that needs to be looked into. Yes, from anti-defection, of course, we move to the election law cases, and for election law, the first judgment that we need to look into is the electoral bond judgment, which is saying that the electoral bond scheme is unconstitutional because it is not transparent, not fair, and therefore people have the right to know whom they are voting, who is financially supporting them, who is giving them the funds, and therefore because it lacks transparency, we cannot hold it just because to protect the secrecy of the donor. And this is against the doctrine of proportionality as well. So court in this case has directed that the information should be made public on the website of Election Commission. Okay. Then coming next is the case of we have the case of Abhiram Singh versus C.D. Komachan. In this case, the court is interpreting Article 23, Clause 3 of the Representation of People's Act, which is basically declaring speeches hurting religious sentiments or religious speeches as a morally corrupt practice in the election proceedings. Now, in this case, the court is saying that remarks regarding any religion, whether the religion of a candidate, whether the religion of his agent, whether the religion of the people, or any person's religion will be included in the corners, in the four corners of in the four corners of corrupt practices, if the speech is being used to transpire votes in favor of one person and against some person. Now, next is the case of Sita Soren. In Sita Soren, it's a case based on parliamentary privileges and it deals inside the Legislative Assembly corruption. Okay. So Sita Soren overrules the earlier PV Narasimha judgment and holds that parliamentary privileges cannot cater the corruption that happens in the parliament. Once it is established that a person has taken a legal gratification for tweaking his duties, then that will be corruption under Section 20 of the Prevention of Corruption Act. Presumption is arising and parliamentary privilege cannot protect that because parliamentary privilege is a part of colonial rule that is carried on in constitution and we do not require the same any longer. Okay. Now, when we look at corruption, section 20 of the corruption, we are also looking at Neeraj Datta's case, which is numbered at 68 in the list of AoR leading cases. Now, Neeraj Datta is basically holding that once you have taken illegal gratification, presumption lies in the favor of accused that he has obtained illegal gratification for corruption only. Okay. So that is Neeraj Datta's case. You can visit the case that is uploaded on the website for a detail on our channel only for a very detailed version of the case. Okay. Now, moving on from election law and corruption, we go to the cases on federalism. In federalism, we have the case of S.R. Bomai. We have Rameshwar Prasad, both the cases. S.R. Bomai is at number 8 in the list of AoR leading cases. S.R. Bomai is upholding federalism, and it is saying that Article 356, President rule, that the President proclaims for state emergency, it is not immune from judicial review. And, it should not be done on the subjective satisfaction of the governor itself. Also, this is being reaffirmed in Rameshwar Prasad at number 22, holding that governor cannot just initiate the proceedings and for state emergency only on the basis of his subjective evaluation, because otherwise it will be an exercise on his whims and fancies, and therefore the check for constitutional breakdown of machinery has to be abided by. Okay, once a floor test says so that that there is a breakdown of constitutional machinery, no confidence motion is passed, only then the proclamation can be made and the information can be, and only on that satisfaction the president may proclaim emergency under Article 356 of the Constitution. This is in the light of the federal structure of Indian Constitution as well. Okay. Now let's come to yes, when we do federalism, we do one important judgment, which is our Article 370 abrogation, okay, is numbered at 77, which is talking of asymmetric federalism as well. So it is saying that in India, we do not have a rigid federalism, but rather we do have an asymmetric federalism. Jammu, Kashmir, Nagaland, and other tribal areas being an element of that. Okay, in this case, Article 370 was abrogated because Article 370 has one word which provides temporary, that the provision was temporary in nature, that the special status was temporary in nature, and it will be revoked once the conditions are established. So section Article 370 therefore was abrogated. The special status of Jammu and Kashmir was abrogated, was revoked, and Jammu Kashmir is now divided into two territories, union territories, one being Kashmir and another being Leh and Ladakh. All right. However, Jammu Kashmir elections are held they will be held by way of in Jammu Kashmir Reorganization Act, but not in Leh and Ladakh. Leh Union Territory elections will not be held. Okay. Now we come to another topic. Okay, we are moving on to CBI. Because in CBI related cases, there is also a federal structure involved. Okay, so we will look at the case of, I'll just come to those cases. Yes, we are going to look at the case number 1 at 25th, which is State of West Bengal and others versus Committee for Protection of Democratic Rights Bengal. In this case, CBI, the High Court of Calcutta directed CBI to take on the investigation. So whether High Court can do that or cannot do that, that is what this case is looking into, because CBI is an agency under union government. Only under Delhi Special Police Establishment Act, CBI's powers can be invoked. Okay, so court herein is saying that Section 6 of the Delhi Special Police Establishment Act puts a restriction that it has to take suggestions from the government only in the cases when executive action regarding CBI is being invoked. But judiciary can direct CBI to investigate the cases if the case so warrants. However, this exercise should be done sparingly and not casually. And court herein is iterating that in India we have cooperative federalism. Okay, so we are not rigid like USA, but rather we do have a cooperative federalism. It's not a competitive federalism, and therefore high courts do have a power to issue directions to CBI to investigate a case. Moving on to CBI itself, there is another case which is Union of India versus V. Sriharan alias Murugan. And in this case, this is basically Rajiv Gandhi assassinations case. And in this case, the Tamil Nadu government commute sentences of the accused, whether they can do so because these were investigated by CBI. The court is looking at section 433, 432, and 435 of the CRPC, and holding that the offenses which are investigated by the central authorities like CBI, that cannot be commuted just by the state. They have to take union government into consultation before doing so. So 432, 433, 435 are being interpreted of CRPC in this case. Okay. Now we move on to another element. Okay. Yes, now we are moving on to another theme. Okay, this theme is the women and gender justice theme. Okay, in this theme, we are going to look at the cases relating to women. So we will start with sub number first, 13th number case. Now the 13th number case is Vishaka and others versus state of Rajasthan. It's a landmark judgment. We know posh guidelines were given in this case against sexual harassment, but what guidelines are to be issued, the court is looking into it, and court is exercising its 142 jurisdiction. We will come back to 142 jurisdiction after this theme. So basically, Vishaka is issuing guidelines for prevention of sexual harassment against women at workplace, and it is one of the judgments, one of the pioneer judgments for in the area of women justice, female jurisprudence in India. Then when we look at Geeta Hariharan and another versus Reserve Bank of India, in this case, the court is interpreting that father and mother are equally the guardian, and in absence of father does not mean that father has to die so that mother can be a natural guardian to a child, but rather in the physical absence of the father also the mother acts as the natural guardian. So this judgment is putting both mother and father of a child at par when it comes to guardianship. Okay, it is a judgment under Hindu Maintenance and Guardianship Act. Okay, now let's come to the another case. This is NALSA. We are moving towards gender justice now. NALSA versus Union of India. Now, in NALSA versus Union of India, recognition of third gender was given. It was held that in all the government firms, in all the firms, there will be a separate identity that should be allotted for these people. Directions regarding identity of transgenders was given. Right to privacy was invoked, and the court in its very first judgment gave a legal status to identity of transgenders and third gender people. Moving on to the case, following the lead of NALSA, following the lead of NALSA, we had Joseph Shine. Just a minute, I'm looking for the judgment. Sorry, Navtej, pardon me. We had Navtej numbered at 47. In Navtej, 377 was decriminalized. In 77, homosexuality was an offense, and it was decriminalized in the light of NALSA as well, right? So now, moving on to another judgment on women justice, on gender justice and women justice, we have Shaira Bano as well. Now in Shaira Bano, triple talaq was criminalized because it was violative of the rights of Muslim women. And the court is highlighting that how anything that is a prolonged practice, it cannot be made a custom if it is in violation of Article 14 of the Constitution of India. Article 25 is also subject to Article 14 and other fundamental rights as well. So in Shaira Bano, triple talaq was made an offense, and an act was subsequently passed in 2019, which makes triple talaq, the practice of triple talaq, an offense in India. Then comes the case of Shakti Vahini. Now in Shakti Vahini, the court is looking at Khap Panchayat, holding that Khap Panchayat is not a constitutional or statutory body, and it cannot give its verdicts on honor killing. So that practice is not allowed in the Indian context, and these judgments do not have any legality which is being given by the Khap Panchayat. So this is a judgment against honor killing, holding Article 14 and Article 21 for the victims of honor killing. Okay. building on, of course, that right to marry a person of our own choice is our own choice itself. Okay. Then next and last in the list is the case of Joseph Shine, adultery being decriminalized, because adultery being decriminalized for 497A being decriminalized, 497 being decriminalized because the court found it as a violation of sexual autonomy. As you know, the court has looked into it that this is a law patriarchal in nature, and therefore it needs to be repealed, it needs to be struck down. So court is reading down adultery in Joseph Stein versus Union of India, also finding it violative of equality, that if you are punishing men for it, why are you not punishing women for it, right? So, section in case number 50, adultery was also struck down, giving gender reasons the cause for it, giving gender cause the reason for it, pardon me. Now, when we look at women and child judgments, one judgment that needs to be discussed for the purpose of Juvenile Justice Act is the Nirbhaya gang rape case, which is numbered at 39, Mukesh and another versus State of NCT of Delhi and another. Now we know that all of the accused, they were hanged to death in this case, even after mercy petitions and so on. But what this case brought is a reform in Juvenile Justice Act, because earlier Juvenile Justice Act of 2000 treated every child same, and the child was therefore acquitted, and therefore not acquitted, but the child was sent to reform center, and then he was released as well with a new identity, the person who was the child who was accused in this case. But you know, with this case, JJ Act brought was brought under a complete overhaul. New JJ Act 2015 was passed, which divided offenses into petty, heinous, and serious offenses. And in the case, if the heinous offense is being committed by 16 to 18 years of age of child, by a child of 16 to 18 years of age, he shall be dealt with as an adult. Okay, so this is one reform that Mukesh and another versus NCT of Delhi is bringing in, the Nirbhaya gang rape case is bringing in. Okay, now we go ahead. As we move ahead, we go to the cases for Article 142. Okay, now what we are going to understand in Article 142 theme is that for under Article 142, the court gives decision to meet the ends of justice. But there are cases where courts are not using Article 142 itself. Okay, so we are going to look into that also, because if you look at Article 142, sometimes it can bring judicial overreach as well, sometimes it can bring judicial activism as well, and sometimes it can bring judiciary to write the laws as well. Okay, so we start with Vishakha. In Vishakha, what is happening? In Vishakha, the court is using 142, giving full-fledged guidelines on prevention of sexual harassment against women at workplace. Okay, but then we come to Rupa Hurra versus Ashok Hurra. The court in this case is using 142. It is bringing out curative petition itself. That curative petition can be filed, and the decision of a court can be challenged, not by way of writ, but by way of curative petition. Now, similar thing we can do, we can look in the case of AR Antule as well. One aspect of AR Antule is judiciary in its administrative action is state, and another aspect of AR Antule is that if the court has given a judgment per incurium that is not right in the eye of law, court can invoke Article 142 jurisdiction, cure the defect in the earlier jurisdiction to meet the ends of justice. Similar is the finding in Rupa Hurra versus Ashok Hurra, and Rupa Hurra versus Ashok Hurra is bringing curative petition for us, in which curative petition can be filed as the last resort even after review petition is dismissed. Okay, then we next come to case number 24. Now, in this common cause case, which is a 2008 Supreme Court case, the petitioner is asking for road safety guidelines by the Supreme Court in exercise of Article 142 and 32 as well. The court is declining so, saying that we do have a full-fledged Motor Vehicle Act and it is not needed. So court herein is not using 142 jurisdiction itself. Then similar is the case of Dr. Ashwani Kumar versus Union of India, numbered at 54 in the list of AoR leading cases. And in this case, the petitioner, he's a PIL activist, and he is saying that Convention Against Torture has to be applied in India, has to be ratified in India, because there are under trial prisoners who are suffering custodial torture at max. Now, the court herein is saying that we are not going to write the law. We are not going to direct the executive to make a law when the discussion on such is going on in the parliament itself. So, court herein is also refraining from exercising its Article 142 as well as Article 32 jurisdiction and not giving any directions to the executive in this case, but rather goes on to expounding separation of powers, that why we are not stepping into it, and because it will become a judicial overreach. Okay. Then in the line is the case of Shilpa Sailesh versus Varun Srinivasan, where court is using 142 jurisdiction to grant a couple divorce because irretrievable breakdown of marriage is not recognized statutorily by the Hindu Marriage Act yet. And the court is basically saying that because it is not a statutory remedy by 142 jurisdiction, only the Supreme Court can do so when doctrine of irretrievable breakdown of marriage can be applied. Okay. So these are few cases which can be written thematically when there is a question arising on Article 142. Moving on to the next article, we have Article 143 of the Constitution of India, which has been interpreted in the case of In Re Special Reference number 1 of 2012, where a presidential reference is made. This case is clarifying that if there arises any question of public importance, be it not be just a mere doubt of president, the president can make a reference under Article 143 to the Supreme Court of India. The advice is not binding. Whatever the advisory opinion is rendered by the court, it is not binding on the president. And also, if the court finds some good compelling reasons to not entertain the reference, the court can also deny it to do so. Okay, but the reasons should be compelling. For example, the matter is not of public importance, the matter is entering into political realm or so, court may deny it because the terminology used is may and not shall. Okay, now we come to the next case, next portion, next segment. It is the environment law domain. Okay, so in environment law, we are looking at Well-Law Citizen Forum's case, and Well-Law Citizen Forum is basically talking of precautionary principle and polluter pays principle. It is bringing these two principles in Indian jurisdiction because it wasn't there earlier. So following pursuant to the Stockholm Convention and Rio de Janeiro Convention, these two principles are finding their applicability in India through Well-Law Citizen Forum's case. Another is numbered at 41, Common Cause versus Union of India, pertaining to mining. So some mines in Orissa were operating and they haven't got environment clearance. So court is directing state government that clearance should be given to them. The lease should be renewed for them if they have aligned with the environmental clearance, and court is directing state to look into the matter. And next is the next topic we will look at is, now we are going to look at, with this, we are done with the Constitution of India. We are done with majorly the cases which are relating to Constitution. And now we come to other cases. Okay. So now we will look at arbitration. We will start with arbitration and then we will go on to other domains. Okay, so with arbitration, we start with the number 21, SBP versus Patel Engineering Limited. In this case, the court held that the exercise of Section 11, Clause 6 by Chief Justice of High Court or judges subordinate or judges nominated by him, that is a judicial exercise and not an administrative one. And the court, when allowing an arbitration petition under Section 11, Clause 6, the court has to look at three things: that whether there is an arbitrable agreement, whether there is a life claim, and the dispute is arbitrable in nature, and then go on to appoint the arbitrator. Okay, so the judicial mind has to be applied and not a mechanical rubber stamp. So therefore, it is not an administrative action, and therefore court is overruling the other cases which has led down that this is an administrative action. Okay. Next in the line is Sangyong versus NHAI, where court is elaborating what public policy of India is and also exploring on patent illegality, that whether patent illegality will be applicable in this case or so. Okay. Then comes the Cox and Kings versus SAP India group of companies doctrine. Approach is deviated. We are deviating from the Chloro case, and the court herein is holding that now group of companies doctrine is also working on the consent-based approach, and a deviated approach from Chloro is being taken in the case of Cox and Kings versus SAP India. Group of companies doctrine is in consideration. Then we come to the 76th case, interplay between arbitration agreement and arbitration act. Under Arbitration Act and Stamp Act, the court is saying that just merely because an agreement is inadequately stamped or not stamped, it does not harm on its validity. It's a procedural lacuna that can be cured, and therefore procedural lacunas are not much competent to deny substantive justice. So this is what the 4 cases on arbitration are there. We have done a proper elaboration on these 4 cases. You may go and watch these cases separately, right? Now moving on. Okay, moving on, we are going to competition commission cases, competition law cases. There are 2 cases in the list. One is at number 40. Yeah, it is Excel Crop Care Limited versus Competition Commission of India. It is basically, in this case, the penalty when there is a violation of Section 3 or Section 4, when there is anti-competitive practice or abuse of dominant position in the market. The penalty that has to be imposed by Competition Commission is not on the total turnover of the company, but only on the product which is involved in the anti-competitive practice. So relevant turnover shall be taken into account to impose the penalty. That is the interpretation that the court is taking in this case. Next is the Competition Commission of India versus Bharti Airtel Limited. It is basically ruling out that when 2 tribunals are involved, when 2 regulatory authorities are involved, one being the Competition Commission of India and another being the another being the TRAI, which is Telecom Regulatory Authority of India. The court is laying down the precedents that both the proceedings are different, but primacy shall be given to the special unit, okay, the special technical unit to decide the case first, and then it will come to the Competition Commission of India. So TRAI proceedings will proceed over CCI proceedings, and both the proceedings are to take place. One jurisdiction cannot invalidate another's jurisdiction. That is being held in Competition Commission of India versus Bharti Airtel Limited. You can just go back and review this case. It is uploaded in a full-fledged manner on the channel under the playlist of AoR leading cases. Okay. Next are the cases of insolvency 52 and 57. Okay. Now in 52, the court is basically in insolvency and bankruptcy code, because insolvency and bankruptcy code is a code coming in 2016. The court is upholding that financial creditors, there is a distinction that the law is drawing between financial creditor and operational creditors. And the court is saying that this differentiation is reasonably valid and can be upheld. There are some more provisions that were challenged, and the court is upholding all of them, giving them the reasons that are adequate and the reasons, of course, of intelligible differentia when it is differentiating financial creditors and operational creditors. Moving on to 57th is Committee of Creditors of SR Steel India Limited versus Satish Kumar Gupta. In this case, the court is upholding that if a resolution plan is passed by COC, by committee of creditors, then the insolvency tribunal, it does not have the say to rewrite the resolution plan. Okay, and because the reasons that COC is taking in account to finalize the resolution plan are based on their wisdom in the domain. And however, these resolution plans, these decisions of the COC are always subject to judicial review by the court. This is what is being held in case number 57, Committee of Creditors of SR Steel India Limited versus Satish Kumar Gupta and others. Now we move to another cases. Okay, now we are going to the cases on Contract Act. Okay, so in the contract law, okay, yes. So in the contract law, we have 2 cases herein. Okay, one is the Kailashnath case. Now in Kailashnath case, earnest money was deposited with DDA, but the court held that in case the contract is not formed, when the party is not signing the contract, the conditions of a contract is not fulfilled, the contract is not formed. In that case, earnest money cannot be forfeited by DDA just because in the name of penalties under Section 74 of the Indian Contract Act. Indian Contract Act. Okay. Now, next is the case of Mafatlal Industries. It is at number 12 in the list of AoR leading cases, and it is saying that it is basically giving the remedies when unlawfully recovered taxes are imposed. Okay, so in this case, what happened is that company did not know that the tax were being waived off, and the company paid the taxes. Now it is wanting to take the taxes back from the authorities. But in this case, court has said that companies itself have not paid taxes, but rather these were customer-based taxes which were paid by the customers. So once customers have paid the tax, company cannot claim the benefit of it, and therefore the quasi contract that is created, it cannot be used for unjust enrichment. Okay, so unjust enrichment doctrine is in picture here. Now, next is limitation law. Okay, so for limitation law, we come to case number 17, first P. Ramachandra Rao versus State of Karnataka. This case holds out that there cannot be any limitation in the criminal cases. Otherwise, it will refute the very purpose of disposing criminal justice. The arguments are made that speedy trial, to ensure speedy trial, it should be there, but court is saying that right to speedy trial cannot cannot be invoked herein to impose limitation on trials and criminal trials per se, because there can be multiple reasons of filing a complaint late. So we cannot impose limitation in criminal trials. However, reasonable time has to be taken in account, latches have to be taken in account, but limitation is not something that finds its applicability in criminal trial per se. Another case on limitation is the case of Shanti Conductors Private Limited versus Assam State Electricity Board. Now, in this case, the petitioners are going in review and they are taking defense of Section 19 of the Limitation Act. Okay, but Section 3 is already playing in, and their claim was already dismissed in the lower courts because limitation period has expired. So now the court is saying herein that the grounds of Section 19 were not raised at all in the earlier stages of the litigation, and therefore they cannot be taken up in review as well. So court is dismissing the claim. The video is, of course, uploaded on Contract and Limitation on the channel. You can go and see them. If you need any more information, any more subjects to be covered, any more cases to be covered, any information that you want me to upload the video on, you may write to me at legaldarshan@gmail.com. The email ID is in the description box below, or you may, comment down also. Okay, now let's move to another domain. Okay, now this domain is the international law. Okay, so we have two cases. One is the Technip versus SMS Holding. In this case, basically we have discussed this case. Now the companies in question, okay, one French company acquires another French company, and the company acquired by the another French company has a subsidiary in India. So the court is basically looking at which law will apply here to look into the acquisition, to look into the formalities of acquisition. The court is saying that French law will decide how the acquisition, what the acquisition has happened, in what way. But for Indian subsidiary, Indian compliance has to be made. Okay, so that is what the court is observing. This is a case of private international law where we are deciding what jurisdiction will be invoked. Another is the case of Republic of Italy versus Union of India, where Italian Marines, they killed 2 Indians, and Tamil Nadu, the state of the state of Kerala, invoked the inquiry on them and arrested them. So can a state arrest foreign individuals who were the Marines, who were the bureaucrats of that nation. Can that be done? The court is saying no. It has to be done by central government. A special court has to be constituted. The state government do not has the power. The state machinery does not have the power to do so. This case went before arbitration, and the Italian government paid compensation to India later on, but that is what the crux of Republic of Italy versus Union of India is. So law of the sea is involved herein. That you can go back and look at the judgment for a detailed discussion. Okay. Now we come to, now we are coming to the criminal trial. And then we will cover the remaining judgments. Okay. So now we are coming to the criminal trial. And for criminal trial, we start with DK Basu. DK Basu being the landmark judgment, numbered at DK Basu being the landmark judgment numbered at 11 in the list of AoR leaking cases. DK Basu holds the right of arrested person because it is a judgment that is highlighting custodial death and custodial violence at it, and the judgment issues some 11 guidelines. Now, this is also being issued in 142 jurisdiction, and the guidelines are issued Article 132 and 142 jurisdiction, and the guidelines are providing that what rights of arrested persons are, how they should be complied, invoking Article 22, also invoking the relevant provisions of CRPC as well. Next is Arnesh Kumar. Now, Arnesh Kumar is basically the DK Basu is telling us the rights of arrested person. Arnesh Kumar is telling us how an arrest can be made. So procedure under CRPC has to be complied. And in cases of 498A, the police officer has to make an inquiry, has to make it a fit case for the arrest to be done. Because when Arnesh Kumar happened, many of the cases were filed under 498A, and because it was a cognizable offense, the person was being arrested directly. So court is ordering that we need to look into the factual determination whether arrest is required or not. And following Arnesh Kumar, we have Satyendra Kumar Until, which is numbered at 70. Now, Satyendra Kumar Until is saying that bails can be given wherever it is possible. It is classifying offences into 3 categories: one with lesser than 7 years punishment, one with punishment 7 years or more, and one with the offences which have stringent penalties, for example, UAPA, for example, TADA, etc. Okay, so court is saying that we need to look into the parameters where bail can be given. Okay, so we have to follow the statutory mandate of bail, and arrest only are needed to be made where the situation is gruesome, that it demands that, the compliance has to be made to the procedures established under CRPC, so that overcrowded prisons are not more filled with the prisoners who are basically under trial. Because in Satyendra Kumar Until, we observed that the prisoners were under trial prisoners were forming 75% of the total prisoners. Okay, then moving on, we go to bail. When we are talking of bail, we have the case of Sushila Agarwal, and in Sushila Agarwal, the court is reaffirming Gurbaksh Singh Sibiya's judgment, holding that just because you got an anticipatory bail does not mean that you have to surrender, or you will not be granted statutory bail later on. So that is what Sushila Agarwal is predominantly saying. And then when we go to another cases, in another cases, we have the case of Lalita Kumari. It is numbered at 33. Not 33, 31, pardon me. Lalita Kumari is basically highlighting FIR, that what is the that whether before registering FIR, police officer is required to inquire. The answer in Lalita Kumari was no, that as soon as there is an information received FIR can be registered. However, this view is tweaked in the new BNSS as of now. Okay, now we go on to completion of trial. When the trial is completed, is being determined in the case of Sukhpal Singh Khera versus State of Punjab. The court is saying that a trial is completed when the court pronounces conviction, the court has made an order for imposing the punishment, and in case of acquittal, when the accused is acquitted, the trial is then complete. Okay. Now in evidence, we have 2 judgments. One is Sharad Birdichan Sarda at number 4, which is talking of the Panchsheel principles for circumstantial evidences. And following Sharad Birdichan Sarda at 26, we have Selvi, which is talking of the authenticity of the narco analysis test. It cannot be done involuntarily. And and it can only be done voluntarily, keeping in mind the self-preservation against self-incrimination principles. It is complying with Article 20, Clause 3, as well as the confessions, as well as the provisions on confessions that is there in the evidence law, that is there in Bharatiya Sakshi Adhiniyam and the earlier Indian Evidence Act. Okay, so these were the cases on particular domains. Now, there are many cases which do not find a specific domain. We are going to discuss them one by one. Yes, we are going to do the case number 29, which is Novartis. And in Novartis, basically, the court held that the substance in question is not a novel form, but rather it is an already old form of the existing substance, which was imatinib mesylate. And the court is invoking Section 3, Clause D of the Patents Act here, which is saying that just because you have discovered a new form of a known substance, it does not guarantee you a patent. Okay, so in this case, the court rejected the patent because the substance that was to be patented was merely a different form of an already registered substance. Okay, now 30 is medical negligence case, Dr. Balram Prasad versus Dr. Kunal Saha. Now, in this case, basically, the award was granted, okay, for medical negligence of the doctors, but the litigation was prolonged over more than 15 years. So this petitioner is saying that I should be given interest on the prolonged case as well, and the penalties that are to be imposed, the compensation that is to be given to me shall be increased, in light of the expenses today. So the court is granting him that. Moreover, in this case, some claims were granted, some were not granted. For a detailed discussion, you may go back and look at the judgment. Okay, basically, it's a medical negligence case, and interests were awarded because there was a prolonged litigation, and the petitioner's wife has suffered a lot in this case. Okay, then next we come to Shreya Singhal. Okay, so Shreya Singhal is the case where Section 66A is struck down because the language of was very vague, and it could make anyone come in the scrutiny who was exercising free speech on the internet platforms. Okay, so Section 66A was struck down, but another provisions in challenge 69A and 79A were upheld. Okay, now next is Gujarat Urja versus MCO. In Gujarat Urja Vikas Nigam versus MCO, we are dealing with IT Act accelerated depreciation. Court is saying once you have claimed the tax benefits, you cannot go and revise the tariffs. So that is what is being held in Gujarat Urja Nigam Limited. Then next is Municipal Corporation Ujjain and another versus BVG India Limited. This is again a case on judicial review on administrative action. Now, basically, when an administrative authority is exercising its decision-making power, court can do a judicial review, but court cannot do a judicial review of the merits. So court does not sit in appeal. Courts only sit as an examiner whether there is any procedural lacuna or not. So if there is no arbitrariness, no violation of any rights, no violation of 1421, the judgment is proportional, it is well reasoned, then the court cannot go and change the merits of an administrative discretion. That is what is being held in Municipal Corporation Ujjain versus BVG India Limited. The case is uploaded. You can go and have a look at it on the already published cases. Then next we come to Internet and Mobile Association of India versus Reserve Bank of India. Now this is a case relating to cryptocurrency. In 2018, April 2018, the Supreme Court issues guideline. The RBI issues two circulars that banned the banks from being involved in trading of cryptocurrencies and being involved with individuals who are involved in trading of cryptocurrencies. The court is striking off such circular, holding that there is no law which makes cryptocurrency illegal in India, and therefore RBI cannot go beyond the scope of cannot go beyond the scope of using its administrative powers, using its quasi legislative powers, and therefore the regulation was struck down as it was also violating proportionality. It was a disproportionate notification as well. Okay. Now, Nandini Sundar versus State of Chhattisgarh is a case finding its applicability under Article 21 as well as Article 14 of the Constitution of India. In this case, the court is striking off the appointments of special police officers. Okay. These special police officers are not somebody who are, recruited through the police appointments, but rather these are the members of tribes who are being recruited by police officers for special tasks against Naxalites. Okay, now these people are not given any benefits. These are paid. They are paid task based, and once the task is done, they are relieved from the services. There is no protection that is being given to them. So these tribes are known as Salva Judum, and now the petitioner is claiming that there is a gross violation against these people because what they did, they attacked the village. And it is not just the violation for the civilians, but rather it is a violation for these people who are appointed as special police as well. Because once the task is done, they are left with nothing nothing at hand. So court is criticizing this practice as anti-human rights and is holding that such practice should not be continued. Okay. Now, next we are going to do the case of Property Owners Association and Others versus State of Maharashtra, numbered at 85. This case is holding that whether private property can be redistributed in the light of Article 39 of the Constitution of India, promoting distributive justice. The majority opinion is saying that no, private properties are not the property belonging to public resources and it cannot be redistributed. You can go back and have a good look at the case we have already discussed. Okay. Now we have Mineral Area Development Authority versus SAIL. It is basically discussing that whether the royalty that is being paid, whether it is tax or it is not tax. Majority opinion is holding that it is not tax, but rather just a lease amount being paid. It is in the nature of a lease being paid. Okay. Then we come to the last two cases that needs to be done. One is Indore Development Authority versus Manohar Lal and others case. And on 6381 is being built, State versus BSK Realtors. Okay. So these in this case, in the case of Indore Development Authority, we are interpreting the 2013 Land Acquisition Act. Okay. So 2013 Land Acquisition Act is basically in this case, the court said that two conditions are to be satisfied to lapse the acquisition proceeding. So that acquisition proceeding has lapsed. To determine when acquisition proceeding lapses of before 2013 Act coming into picture and acquisition being governed by the earlier Act, we have to look at two things. One, that the compensation is received by the party, okay, whose land is acquired, and state has acquired the land. The state possession is with the state. So both of them once satisfied, not one of them, both of them once satisfied, the acquisition proceeding will be called as lapsed. Okay. Now building on this case, we have 81, case number 81 as well, in which the court is relying on the decided case of Indore Development Authority versus Manohar Lal, and is re-giving the relief. Okay, because earlier in this case only there were twofold litigation. Relief was earlier denied in the light of an earlier precedent, and now when that precedent got overruled by the Indore Development Authority case, the court is re-adjudicating the matter and allowing the acquisition costs to be paid in this case, citing public interest to be involved in this case. And court is saying that when public interest is involved, you don't need to go into looking whether res judicata will apply or whether the case is already being decided. But and of course, when it was based on a precedent that is now overruled, justice needs to be served. Okay, so this was 86 cases that we have discussed so far in the list of AoR leading cases. I hope the discussion is useful for you. I hope there is no case left. I hope you can make the good use of this video that I am delivering as a last and final content in the series of AoR leading cases, right? So we have discussed all the judgments so far, made interconnections between them, and discuss them separately as well on the platform. Okay, we will be bringing more series on the topics relating to public law very soon. I hope you are liking the content here. And for more such videos, please stay tuned with us on Legal Darshan. It will be appreciated if feedbacks and some comments can be dropped on how you have liked this series. Thank you everyone for watching. For any more suggestions, any more recommendations, please feel free to comment below. And also you can mail to me at legaldarshan@gmail.com. Thank you everyone. Have a nice day. I wish you all the best for the upcoming exams.